the cases of the people of the state of Michigan versus Omar Smith and Jamal Jones. Council is all present as well as the defendants. You may proceed.
People move for bind over on all counts for defendants. There's been significant evidence that's been presented, I think, on both sides, but most of that raises questions of material fact that are province of the jury. People have established proof sufficient to establish probable cause on all counts. We ask the court to bind it over.
Response.
Thank you. Judge, on behalf of Mr. Smith, I'm going to object to a bind over on count one. I would of course like to, in good faith, I'd like to be able to ask the court to deny a bind over on counts 2, 3, 4, and 5. But I know that in a hearing of this sort, where the court people present their evidence, court doesn't have to take the state's evidence in the light most favorable to it, but it does have to consider the evidence. And the evidence presented, I think, is while I ultimately think were to get to a trial on counts 2, 3, 4, and 5, we'll have certainly arguments to make to the jury about those counts. Again, I can see the people asking for a bind over, and while I object to it, I could understand the court binding over on those counts. So I'm going to formally object without arguing counts 2, 3, 4, and 5. But count one, I do not believe that Your Honor should bind over on. I don't believe that when you consider the evidence presented, whether there's evidence on one side or the other, totality of the evidence, no matter how it's viewed, does not support a finding that Omar Smith committed murder. Significant questions can be asked, but those questions ultimately lead past the question of self-defense. They lead to one of the questions that I put to Detective Dunn, which was, do you even know what round or caliber or firearm from which person ended up being the lethal shot? Do we even know who killed? Even if we put aside questions of self-defense, questions of whether or not these individuals had a right to respond to Thomas's possession of a high caliber firearm or of a high output magazine or of a gun of that nature. Even if you put all that aside, the seminal question you're being asked by the people is to bind Mr. Smith over, saying that he killed Lamar Thomas. And there is no evidence as to whose gun killed Lamar Thomas. Did it come from Mr. Smith's gun? There's no evidence of that. Did it come from the co-defendant's gun? There's no evidence of that. They do not know. You do not know whose gun from whose hand ended up killing and causing the death of Lamar Thomas. That, in my mind, is a fundamental shortcoming of the state's case and requires a dismissal of that count against, as it relates to Mr. Smith. There are cases that I know the court is aware of them, that even if you were to get past that question, that you are still required and should to consider validly raised and legitimately presented defenses. And in this case, there is a legitimate defense that was raised before the court. I think it's inherent in the proofs that to the extent that one could even argue that Omar Smith caused the death or did murder Lamar Thomas, that his use of force was in self-defense. And self-defense instruction.
Well, but I can't I'll stop you there only because I can't decide self-defense at this stage. Self-defense is basically an affirmative defense that would need to be raised at the trial level. I think the case law is real clear on that.
Well, again, But Judge, at this stage, you're my audience. You are the.
I understand that.
So, I'll just politely say that I think the court can consider it. I think that the court is required to consider issues of credibility. I think the court is required to consider issues of, and defenses when appropriate. And I think that this case screams of self-defense, and I would ask the court to take that into account. Again, I'm not going to waste my time and certainly not going to attempt to waste the court's. I respect your honor. You have your perspective and you have your views. And since you're the fact finder, it wouldn't do me a whole lot of good to sit here and tell you that you're wrong. I'll just say that I respectfully believe that
And it wouldn't be correct, but go ahead.
At that, Judge, it's been an interesting preliminary examination. I'm going to say this. I very much regret that young lives are at stake and that one young person's life was lost. I very much believe, looking at the evidence in the case, that Mr. Smith should not have been charged with murder. I think my view of the evidence in the case, as I went through the file, was that Mr. Smith should not have been charged with murder. My opinion on that subject has only strengthened, and my resolve in believing that Mr. Smith is innocent under Michigan law of the, not guilty under Michigan law of the crime of murder is even more strengthened. I'm going to rely on the proofs and suggest that people have not established enough evidence to bind over on count one. I think I've objected for the other counts, but understand that if the court found the evidence was sufficient to bind over, I would object to it, but understand that given the evidence, the court could very well bind over counts 2 through 5.
Thank you. Mr. Upshaw.
Thank you, Your Honor. Judge, what I would like to point to is two things. The first thing we have to, I think, is undisputed. There was no conspiracy here. Whoever did whatever, there's no conspiracy. There's no allegations of any pre-planned, unified strategy here. The officer was candid and stated that whoever drove up, who you believe to be the defendants, was there first, eating pizza, walked past this shop. When the victim, with my apologies, came out afterwards. Those are the points. The reason I bring those up front, because if there was a conspiracy charge or a pre-planned theory here shown, then we can get into aiding and abetting and all that other stuff. That's not here. Without there being a conspiracy or pre-planned, because I think the OIC even testified, there was a shocking look on somebody's face. And so I'll get to the meat of it. 3 individuals were arrested as suspects from the beginning. I listened to this examination in detail. Regarding this murder, Judge, we can't use speculation and hunches. We stuck that at 4 corners of what came from that witness stand. And I listened very hard for Mr. Jones's name to come out. Judge, Mr. Jones was never accused of doing a shooting at the barbershop. Mr. Jones, I don't know if it's the second individual or the third individual. It's not my duty to prove that element. But what we do have is we have an eyewitness there who was 20 feet away from my client. And she didn't say he did anything. There's one rest chest eyewitness. She's 20 feet from Mr. Jones. She didn't say any criminal act occurred on Mr. Jones, period. No one identified Mr. Jones as being that second or third individual that did the shooting or had a gun at the barbershop. So, Judge, based upon that, there was no need to question because no one said Mr. Jones did anything. Furthermore, officers testified.
What do you do with the video
Video,
outside of the barbershop with the 2 individuals firing?
I seen the video, and I seen an individual in a gray sweatshirt at the point. And nobody, when they seen my client, what they said he was doing was somewhere not too far, but somewhere in the city hopping fences. He didn't have a gray shirt on. No one said that he was individually at the barbershop. The record is totally void of any witness saying that the individual, that my client was at the barbershop, that my client fired a shot at the barbershop. If someone would have came and had some identification, I guess I was expecting it from Ms. Burns or whoever, because the video is very unclear to who that individual was. In the gray sweatshirt, you've seen him from the back. And that's all I seen from the back. I didn't see any features in which any person testified that these features were the features of Mr. Jones. And then I looked at the video when Mr. Jones was arrested. Blue underwear, black shirt, black pants. There was nothing to say here that they met the element of proven identification that Mr. Jones performed the shooting. The second part I would like to say, Judge, not only was he I almost want to say you have to show identification. And you have to rely on the evidence and the testimony that came. And if someone would have came and said, that's Mr. Jones in the gray shirt, I would make my argument, but no one said that. If there was some fingerprints, some ballistics or something of that nature saying it was Mr. Jones, then I would have to argue that. Furthermore, Judge, whoever that individual, just for the sake of argument, murder is an intentional crime. And I'm not going to belabor the issue of that. It's undisputed that a vehicle was shot up, or whoever that third person was, because as I said, I was always informed there was 3 suspects. Whichever the third individual was, 2 guns was already out there shooting before that third person even got involved. And shots were being fired in that third individual's direction. I let Your Honor make your own analysis on that one. Judge, I understand what you're saying about whoever it was and self-defense and things of that nature. But Judge, we just can't get beyond the point that no one took the stand and said, Mr. Jones was driving a car, fleeing and eluding, and I seen him driving that car. So when it comes to the fleeing and eluding charge, no one said he was driving. Resisting obstruction of an officer, prosecutor did a great job of trying to rehabilitate it, but the officer said, I said to stop. And then I said to stop, and he voluntarily stopped. They didn't, he was hopping fences before the officers even came into the picture. So it wasn't like he was hopping fences disobeying the officer. He was hopping fences before they got there. They yelled at him twice, he voluntarily stopped. So I don't believe there's no resisting, obstructing of justice or assaulting and resisting obstruction. Judge, I appreciate your time as always, and I would like to say it, but Judge, I just don't know how you're gonna get past identification. It's not there.
Thank you, Your Honor. With regard to identification, court saw the video. Court views the video, particularly the Vape World video. You have a really good look at the person in the gray sweatshirt, black pants, wearing flip-flops. We have testimony from Officer Gilby saying that he observed those 2 people in that video get into the red Malibu. He chases that red Malibu. The red Malibu crashes. There, Officer Gilby arrests Mr. Jones, Mr. Smith. We see on the video, person with the driver running away. Same person we see in the Vape World video. That is Mr. Jones. Mr. Jones is later taken into custody by Corporal Maxey. He's identified by Corporal Maxey, by Officer Stanky, by Detective McDonough here today. as the person that was arrested there. Now, yes, he's no longer wearing the gray sweatshirt. He's wearing a black t-shirt. However, two important facts I would point out regarding his apparel. First of all, the flip-flops. He's wearing flip-flops at the time of the shooting, and then he takes off running. Now he's arrested in socks. Interesting coincidence. Additionally, if the court reviews the video, the pants he's wearing are distinctive. They're not just distinct black pants. They're black pants with some sort of material. You can see that very, very clearly in Stanky's body cam video. You can see it clearly in the Vaporwave video. Additionally, his ID is found in the getaway vehicle, in the Malibu. So all of those things tie him directly to that. So I think that is sufficient, particularly for a probable cause standard, to establish identity, establish that he is the person there in the Vaporwave video and the Bombay video, firing shots out into the neighborhood. Both defendants are on video shooting at the victim in the case. The victim is murdered by a gunshot wound. People have met its burden with regard to the murder charge as well as all of the attendant counts that go along with that. We would move the court to bind over on all counts.
The court is listening very closely to the testimony in this case, and where I kind of I share in that view that sitting here watching, regardless of how this ultimately plays out of these young lives, it particularly is somewhat distressing if I take a matter of personal privilege, not having anything to do with the court's decision in the case, that I watch these young people that look a lot like me and they end up in this situation. It's horrible. It's also interesting now, as everybody's discussing the neighborhood in this scene, I grew up around there. So I know exactly where everybody is as they're going through the whole thing and what they're doing in terms of where they're going and the like. Just say that as a preface to this, because this whole thing is just, it's sad to watch. It's sad to watch a young man come out of, or walking down the street someplace and then pull out weapons that are modified to go from semi-automatic to automatic weapons, just indiscriminately firing in an area where at any given point in time, that area, there are just a whole lot of folks just going around either trying to get pizza, go to the one of the Asian stores that are down that way, quite frankly, go down to the library, which is a little bit further down, just indiscriminately shooting. It quite frankly, it's tragic enough that one lost their lives. It's, I guess, in some bizarre way, fortunate that there weren't more lives lost. With respect to the proofs in this case, start with the ones that for the court, from the court standpoint in terms of testimony, are as to Mr. Smith on counts 2, 3, 4, 5, and as to Mr. Jones on counts 2, 3, 4, 5, 6, 7. On those, I don't think there's any dispute that the people have shown by a preponderance of the evidence that those offenses have been committed and that this defendant did. The one issue with regard to the homicide that is raised by Mr. Jones' counsel could be significant if one doesn't look closely at the videos. Mr. Overwater, I think, is correct. That is, when you look at the video real close and you see the individual, you see the pants. I didn't need to know the brand of the shoe. I knew that those shoes were not ones that would stay on. And then the individual, Mr. Jones, is found going through a neighborhood over fences, ends up with no shoes, just socks. And And at some point, somewhere, I would suspect shed that the white sweat or white hoodie or gray hoodie, so that he's dressed in the fashion that he's dressed in at that time. But those pants were distinctive. It was interesting that I was going to bring it up and go into it in a lot more detail. But I think when you look at those pants, it's real clear that that's him. That's him that's in front. You also look at some of the facial features that you can see, and it was clear to me that it was Mr. Jones. To any extent that one wants to argue it, I would dare say that in essence will maybe raise an issue of material fact that has to be decided by a finder of fact. But this court is convinced that that was Mr. Jones at that scene. That was Mr. Jones firing that weapon. And I don't think it matters, for the sake of bind over, that I attribute that bullet to, particularly bind over an open murder for these individuals, that I attribute these to which gun, which firearm, which defendant it was fired. At some point when they started acting, they were acting in concert with each other, because they were both firing, both unloading a large number of bullets into that strip mall, and then jointly both got into that vehicle and drove off. I think the record also shows that one could infer that it was Mr. Jones, is his identification, his items, items of ownership, as well as a weapon, are all found in that vehicle that crashed on Lorraine Street. So for those reasons, and so that we're clear, as to Mr. Smith, I don't think there's any issue as to identification. I mean, he's clear as a bell the moment he's climbing on the top of that officer's vehicle trying to get away, that's him. So for those reasons, the court would find that the people have indeed sustained their burden of proof in this case. And so that the record is clear as to Mr. Omar Smith, I would bind the defendant over to stand trial on counts 1, 2, 3, 4, and 5, taking into account all of the information and evidence presented during the course of this preliminary examination. And likewise on Mr. Jamal Jones' case, if that goes off one more time, I'm taking it. On Mr. Jamal Jones' case, I would bind the defendant over to stand trial on counts 1, 2, 3, 4, 5, 6, 7, based upon what the court has said during the course of its rendering of its decision, and the court also indicating that they've taken into account all of the evidence which has been adduced. Therefore, the defendant are bound over to stand trial. As to the circuit court arraignment, gentlemen, you waive formal reading of the complaint, of the information.
Yes,
And how does your client plead?
not guilty.
Defendants, having waived formal reading, pleading not guilty to all counts, court will enter that not guilty plea. Pretrial in these matters will be set for
April 6th at 1:30 for Judge Luke.
April 6, 2026, 1:30 before Judge Hammoud. Bond in each case will continue as denied. Thank you.
Thank you. And I've been asked, oh, I'm sorry.
Got it. We'll get that in a moment. Okay. All right. Thank you. Yes, sir.
I was presented with, someone suggested to me that there may be some precedent for a juvenile like Mr. Smith to be able to hug his family. I don't know if that's the case or not, but someone suggested that there was some precedent for that, and I said
I don't know what kind of precedent you might be speaking of. As
legal, just sounds like that's
something that sometimes happens. That decision And I do not allow it in my courtroom in that way. I just don't and never have. And those decisions as to that contact, I leave with the sheriff's department and our detention center. So I'm not going to allow it. I certainly understand it, but I'm not going to do that.
Yes, Your Honor.
With reference to how folks are going to exit the courtroom, how did you wanted this side to go? All right, so what I'm going to ask is that I'm going to allow those to go out with the victim's advocate. Those that are on this side, I'd ask you to please wait. I'm not picking sides and doing that. I'm just trying to get everybody out of here in an orderly fashion. Thank you.
And Your Honor, as
Yes,
to
sir.
exhibits, do they stay with the file or do we take them?
I will,
I don't think so.
no, I will return them to the respective parties. I think this,
I approach.
yes. The people's exhibit is this one, and I think those belong to defense.
Oh, these are mine. Yep, thank you. Thank you.
Everyone have a good day.
Yeah. You need it for- Pardon? Can I approach the information?
Yes. And just give this to me.
Give our exhibits.
You did that.